This presentation by Henry Gargan from the Southern Environmental Law Center is from the 7th Annual Clean Virginia Waterways Stormwater and Plastic Pollution Workshop.
He works with agencies responsible for stewarding the Southeast public lands as part of the Southern Environmental Law Center's National Forest and Parks Program. He makes sure the agencies are planning and project level processes to protect these precious environmental and cultural resources. He advocates for state and federal policy that protect wildlife species found only in the Southeast. And he's going to share an overview of the SELC's public comments on the EPA's draft national strategy to prevent plastic pollution. So I'll let you take it away, Henry. Thank you.
Great. Thanks so much, Zach. And y'all can hear me okay? Just making sure before I start talking into the void.
Yeah, we can hear you great.
Awesome. Well, thanks so much, Zach and Katie, for inviting me to be here. It's an honor. And like Zach said, I am coming to you from the Asheville, North Carolina office of the Southern Environmental Law Center, which is actually a little bit awkward because I don't know if y'all are basketball fans, but this weekend, Longwood University defeated UNC Asheville in the conference final, earning Longwood a spot in the NCAA tournament. I want to congratulate you all begrudgingly, but did not really enjoy watching that game, but I just think it's a cool coincidence to be speaking to you all at Longwood today. So yeah, like Zach said, I'm going to be talking about primarily our comments on the EPA's draft plastic strategy, which came out last year. And then I guess more generally, just kind of talk about why federal action to address plastic pollution, at least in our view, stands the best chance, or at least is sort of a sine qua non, the necessary component of making a dent in the problems that y'all have been describing today. Let's see if I can get this thing to advance. There we go. Just a little bit about SELC before I get too much further. We're a nonprofit law firm, essentially. So we go to court and participate in regulatory processes on behalf of other nonprofits, primarily in a client relationship. So we don't have members. We're not like Sierra Club or NRDC. We're primarily just a law firm. But we are a law firm with a massive concentration of attorneys here in the Southeast, including in Virginia. And we really just focus in on the issues that make the South unique, but also those issues, as it turns out, can end up being really significant on the national and international scale. But that's how we position ourselves. I could have preempted a little bit of this, but I am an attorney in the Asheville office, like I said. And my primary focus actually is on public lands protection, so working with and sometimes against the Forest Service to manage our national forests. My focus on water quality and water issues is a relatively recent development in my career, so I'm a little bit nervous just how much expertise is in this room, and just hope that y'all will forgive, perhaps my lack of experience in this field, but I make up with it with enthusiasm and excitement, I hope. In a personal capacity, and I'm not here as a representative of Greenworks, but I'm a board member too of a local nonprofit that does a lot to address plastic removal from urban waterways, as well as things like urban forestry and pollinator gardens and native plants and things like that. So this is also a personal interest of mine. So we are involved in plastics work on a number of levels, although kind of like myself, SELC's involvement in plastic pollution as a discrete issue is actually pretty recent. We've been involved in water quality for a long time, but I think, as we all probably agree, the threats and the policy problems posed by plastic pollution are unique in a lot of ways. Local interventions that I've been involved with, and that's primarily the space I've been working in, have been drafting model ordinances. Actually, this started all the way back when I was in law school. That local governments in North Carolina and around the region could use if they wanted to address single-use plastics being usually given out or sold in retail establishments in their jurisdictions. And then also we have lobbyists at SELC who are working at the General Assembly, and well, I guess I work in North Carolina, so I'm thinking of it in North Carolina terms, in Raleigh, to most of the time in North Carolina's case, try to hold back the tide of anti-regulatory sentiment, which unfortunately prevailed last year, which I'll get into later. And then I guess the primary focus of this talk is our work on the federal level, which is working with and advising EPA in its recently declared intent to really take plastic pollution seriously as a discrete issue. So, even though the focus of this talk is on federal plastic pollution reduction efforts, I know many of you are likely involved in local and state efforts, and I don't want to give those short shrift because we're not doing that either. So I'm going to, as I've alluded to, just briefly summarize what the strategy is. There's a lot in there. I'm not going to spend a whole lot of time in that. I'm going to make a general case for why federal action is an appropriate tool to address plastic pollution, probably, as you could guess, for many of the same reasons federal water quality laws are necessary to protect water quality generally. And then get into a little bit about what we had to say about the draft strategy. And a lot of our comments actually weren't about the draft strategy per se, but just reminding EPA of the tools it has outside that strategy right now to do what we think it needs to be doing to protect water quality. So very briefly, the draft plastic strategy, by and large, it's not a proposed rule. It's not a regulatory document. It is kind of a plan to plan. And it's, when it talks about what we can do to reduce plastic pollution, what EPA can do, it's largely focused on things like best practices rather than command and control regulation of industrial or municipal dischargers, which I think is great. I think as lawyers, we're sort of often thinking, okay, well, how can we regulate? How can we sue? And we love, I think, this friendlier, maybe more inclusive approach that EPA is taking with this strategy. And so in this strategy, it sets a very big objective, first of all, of eliminating the release of plastic waste from land-based sources into the environment by 2040. Check my watch, I think that's 16 years from now, a little less now. So we've got a lot of work to do. And I guess it sets many objectives, but sort of the three main ones, and of course there are sub-objectives beneath these, sort of follow the kind of familiar epidemiological inverted pyramid of interventions. So we have first of all, we want to reduce pollution, plastic production generally, specifically reducing production of single-use plastics. Assuming those things are made, we want to get better at managing those materials, keeping them from entering the environment. And then, assuming they do reach the environment in some way, how can we either keep them out of the water, or if they're in the water, get them out of the water? So this is sort of a familiar schedule of interventions, I think, for many folks. And again, by and large, we think that this is great. We think federal action is really necessary. And our comments, even though we sort of have some additional suggestions, are really supportive of the idea that EPA has a big role to play in addressing plastic pollution by and large. And again, I don't want to come across as being dismissive of state or local efforts to organize around plastic pollution reduction, but we really think the best way to make those efforts effective and efficient is for there to be the support of a nationally coordinated strategy, ultimately an internationally coordinated strategy, for a number of reasons that are probably familiar to folks who have done any kind of policy work. And I think the most basic of these is kind of the hydrologic fact of water pollution, which is your jurisdiction can be very interested in reducing plastic pollution, cleaning up its waterways. But if the upstream jurisdiction is less interested or even motivated to have fewer regulatory restrictions on pollutions because it's participating in, some sort of race to the bottom to attract jobs, industry, then there's actually very little incentive for anybody to organize around cleaning up the water if there's this mismatch between the costs of regulating or cleanup and the benefits that accrue to the folks who are paying those costs. We also see, at least in North Carolina, but also I think elsewhere in the country and in the region, a relationship between more progressive localities. I'll use Asheville, where I'm from, as an example, where a progressive locality like Asheville has the experience of trying to do something ambitious, trying to regulate in a way that maybe sort of runs counter to the politics of our state legislature and getting slapped down for it. Sometimes that's by withholding sales tax or tourism tax revenues. And, when we talk to people in Asheville at the city council level, county commission level, we get like a really positive response to the idea of regulating or of increasing plastic pollution, or I guess, reducing single-use plastic pollution. But there's this great fear that the legislature will do something to Asheville and its ability to govern that maybe isn't worth the cost. And then on sort of a different level too, we actually caught the attention of the legislature in Raleigh to a degree where they decided it was time to preempt local governments like Asheville from doing anything about single-use plastics. So, I mean, I think you can imagine how dispiriting it was for me, who's been working on, model legislation for county and local governments to address single-use plastics for many, well, I guess I'll say 3 years, to immediately have North Carolina in sort of a stroke of a pen say, this is no longer a legal option that local governments have under state law. And then sort of kind of maybe elevated even from those concerns, a lot of the problems that accrue from single-use plastic pollution or the production of plastics. So thinking about coastal communities, communities in Louisiana and Mississippi near petroleum refineries, Cancer Alley. I mean, we do not want the cost of addressing the harms of plastic production and pollution to fall on just a select few communities that are bearing the brunt of single-use plastic and plastic production the most. I think it would be better if we could spread those costs out a little bit. And thinking about who is in a position to work with the companies that are sort of at the root, or at least somewhere along the food chain of plastic production and petrochemical production. I think EPA sort of oversees a suite of laws, including the Clean Water Act, that bring it into frequent contact with these multinational corporations. And so we think EPA probably stands the best chance as compared to a state agency or a county government or a city council of getting the ear of these companies and making change happen. So in short, federal action is needed. We're not saying it's going to be successful overnight, but we do think that it's a necessary component of any effective response to plastic pollution. So the problem is, and this is sort of what environmental lawyers are always coming up against, is that we haven't really had any significant new anti-pollution legislation from Congress since about the 1990s, give or take. And so we're always sort of consulting the old text and asking, what can federal agencies do to tackle X environmental problem, and here, plastic pollution, with the legislative authority they already have? And that's kind of where our comments come in. So our message is, first, of course, as I've said, we support strategizing around ambitious pollution reduction goals, but we also wanted to remind EPA of the tools that it already has to address the presence of microplastics in our waterways starting today. So we focused on a couple of different statutes. Clean Water Act is the one I'm going to talk about today. We also discussed RCRA, the Resource Conservation and Recovery Act, but the Clean Water Act, and I apologize, I never know how much background knowledge folks have coming into a talk like this. So if this is either condescending or just going too quickly, I apologize. My email will be at the end of this presentation. But very broadly, the Clean Water Act is a really useful tool. Many of you probably know it's done a great amount of good to make water safe and better habitat over the years that it's been around. And the basic principle of the Clean Water Act isn't just to reduce pollution or to keep an eye on pollution. It is, in fact, ultimately to eliminate the entry of pollution from discharges into our waters. So it's a really ambitious statute. And accordingly, it prohibits the discharge of any pollutant from any point source into our waters without a valid permit. And so for every pollutant that's in a discharge, there has to be some kind of control, a minimum level of control that must be imposed by that permit. Microplastics, I don't think this is really up for debate, are a pollutant as defined by the Clean Water Act. And therefore, permitting agencies, sometimes it's the state, sometimes it's EPA, may and arguably must address microplastics by setting that minimum level of control in permits for point source discharges. So that feels very simple, very tight, very cut and dry. One other thing to know about that dynamic is just because a pollutant doesn't have a regulatory limit that's been set by regulation, either by EPA or the state, that doesn't let permitting agencies or applicants for permits off the hook from making sure that pollutants are being controlled. The backstop that's provided by the Clean Water Act for these pollutants is something called a technology-based effluent limitation. And what that really means is just the acceptable level of this pollutant in your discharge is equivalent to the level of reduction that is attainable by a demonstrated technology for reducing that pollutant. And the great thing about this is ideally over time, technology gets better. We get closer and closer to the Clean Water Act's goal of eliminating pollutants from discharges. The way this works in practice, the EPA either set sort of a national effluent limitation guideline. They don't do a great job of this. There are, I think, only 59 industries for which ELGs have been set. Or, as is often the case for industrial dischargers, the permit writer will look at what's in the discharge, what technology is out there, and set the limit using kind of their own, kind of a vibes-based sort of thing. But it really is, pretty rigorous actually. But I think it sounds kind of weird. Their best professional judgment. Right now, we don't have any ELGs that are applicable to microplastic pollutants. So, like I said, it sounds pretty simple, pretty cut and dry. So, like, why is this not happening yet? Well, as it turns out, and this is our experience in North Carolina primarily, state agencies are not very good at using T-bells, which is, sorry, I don't know if I even, that's what I'm calling technology-based effluent limitations. And they don't do a really good job of doing that, even when it would be pretty straightforward, even when there is demonstrated technology that can get the pollutant level down below what the sort of established water quality standard is. And this is something I know less about, but I understand that right now, at least, there are, not a ton of really good technologies out there for removing microplastics from wastewater at large scales. And also what we hear from permitting agencies when we bring this to them is that they just don't have the internal capacity to do the sort of scientifically rigorous work of evaluating, okay, what's in this discharge, what technology is out there, what's reasonable on sort of a cost basis to ask of this permit applicant. And we agree that does take a lot of work. I mean, of course, there's going to be political friction too from permittees, whether you think it's justified or not, when the cost of treating their wastewater continues to go up. So just to acknowledge, there's a reason this hasn't already happened. We're not geniuses who have kind of come up with a secret magic bullet in the Clean Water Act to solve all of our plastic pollution problems. So then, the next question is, well, what's the use? I think this is sort of where EPA has to kind of take the lead and get creative. We've seen in our own practice that when the EPA sort of comes down on states and says, hey, we've delegated this Clean Water Act program to you to run effectively. You're not doing what the Clean Water Act asks. Shape up. That can be effective on its own. But they also have a certain amount of sway when it comes to funding. The draft strategy does mention things like increased funding. And we think that, increasing funding to state agencies, permitting agencies, or even EPA itself to develop better technology-based effluent limits for microplastics and discharges would probably be money well spent, because we do acknowledge it takes a certain amount of capacity, but there are efficiencies that EPA can provide, primarily by developing effluent limitation guidelines that are applicable nationally that take some of that burden off of permit writers in state agencies. Also true that best professional judgment can take into account the cost and cost effectiveness of technologies that are available. And even if we don't have a great technology at the moment, that's available for reducing microplastics and discharges, there's something I think really valuable about requiring applicants to basically tell us, first of all, how much microplastic is in your upstream, downstream, and effluent, and also kind of shifting that burden to industry, which is sort of the design of T-bells, of technology-based limits, to basically ask them to come up with better and more cost-effective ways of reducing pollutants in their waste stream. That's sort of kind of the idea that, it might even be cost-effective for industry to invest in, R&D that gets better results when it comes to microplastics. And if we're not willing to acknowledge that microplastics are a pollutant that fits within this framework, within this policy that the Clean Water Act has to force this kind of development, we're not going to really get the same results. And so again, like I said, we don't think that this is going to transform plastic pollution control overnight. But I think our goal here is really just to remind EPA that, if it has the resources, it can direct them in this direction, because it has this authority where it's been pretty effective in addressing other kinds of pollution before. And if it's looking for a source of authority to take action, it has that authority right now under the Clean Water Act to work with dischargers to to start addressing microplastics in discharges. And I think something that maybe gives us a little bit of hope is just kind of comparing what we'd like to happen with microplastics to what we're starting to see happen with PFAS. So as folks here probably know, PFAS are just really dangerous, and they're increasingly ubiquitous. And of course, sometimes they're also really difficult to trace. I think something to note here is that the Clean Water Act, if you're taking in water, you're doing something with it and discharging it, it doesn't really care about what you're introducing while you're using the water. It really just cares about what's coming out the other end. And so PFAS are sort of a good case study of this, where even if you didn't put the PFAS into the discharge, even if it was there when it came in, if you are discharging, you are responsible for what's in the discharge when it comes out. So microplastics are sort of similarly situated here. EPA has also identified PFAS as well as microplastics as an emerging contaminant, which I think is just sort of a useful reminder that EPA acknowledges, at least in the PFAS context, that even when we don't have all the information, whether it's about the danger associated with the contaminant or the technology required to clean it up from wastewater, there's still a legal obligation to do something about it. And just making that comparison, I think, is fairly helpful. And we're beginning to see that kind of action from North Carolina, using this sort of technology-based tool it has in the Clean Water Act to address PFAS contamination in waterways. But here's just an example of kind of what that looks like. And I think it's important to note, too, the impact that political and public pressure can have on how a state permitting agency actually implements its obligations under the Clean Water Act. We see T-bells used infrequently in many contexts, but I think when something is sort of as high profile as a big spill of a PFAS compound, this is for Chemours, which is a big plant in North Carolina, I guess in the Haw Cape Fear Basin. So suddenly we get T-bells, and we're very grateful for them. But I think it's just good to note that this is something that's possible when EPA sort of brings its weight to bear and elevates an issue in a way that really forces states to sort of sit up and take notice of what's being asked of them. And EPA, for its part, it can take action too. I mentioned earlier what EPA can do to reduce regulatory burdens on state permitting agencies. One of the efficiencies it can create is setting these guidelines. And so early last year, EPA announced that it was going to be setting limits for PFAS compounds, at least a few of them. And I think what we hear is this makes it a whole lot easier for state permitting agencies to just sort of plug and play limits, and ultimately just creates a lot more action where maybe there would otherwise be inaction. So again, there are many probably salient differences between PFAS and microplastics, but I think it's just useful to sort of see kind of an awareness of what can happen and how these tools can be used in a similar context, and hope that maybe we can get a similar outcome for microplastics. That's what I had to share with you all today. I hope I didn't go too far over. I want to leave a little bit of time for questions or comments, but you're also welcome to shoot me an email at the address here if we don't have time today. And once again, thanks to Zach and Katie for having me. This has been great.
And thanks for sharing all of your work, Henry. We really appreciate it. Do we have any questions in the room for Henry?
My question is about point source versus non-point source water pollution, and your presentation is mostly focused on the point source options that are available through the Clean Water Act, and I was just curious whether there were any options for any non-point source pollution.
Yeah, that's a great question. I mean, we're frequently frustrated in working with local governments and on their stormwater plans. I mean, I think, and this is frankly, the non-point source side of things is frankly something I know a little bit less about. I mostly focus on point source discharge permits, but I think that's something that I would love to work a little more on. I know, I've got a colleague here in this office who does a lot of non-point source discharge work. His name is Jamie. And I could probably throw his email in the chat if anybody is interested, but I apologize for not having a better formulated answer to that.
Do we have any questions online for Henry, Katie?
Yes, actually, we're very happy that one of the participants online works for the EPA. He's the national program lead for trash-free waters and was the co-lead on developing that national plastic strategy. And I think rather than try to rephrase his questions, I'll ask him to unmute and introduce himself briefly and comment or ask questions. Romel, are you able to do that? Sorry, I'm trying to get him to unmute.
There you go. Can you hear me now, Katie?
Yes, perfect.
Yep, we got
Okay.
you in the room.
Okay, great. Thanks, Zach. Thanks, Katie. And thank you, Henry, for your presentation. Yeah, it was very interesting to see you on. Again, I'm Romel Nandy. I lead the Trash-Free Waters program for EPA within our Office of Water, and I am also the co-lead on the plastic strategy that Henry was just speaking about, along with our Office of Land and Emergency Management, which is our solid waste management and recycling office. So, Henry, believe it or not, I actually recall reading the Southern Environmental Law Center's letter. I remember it being quite a lengthy letter, in fact. And we only had 91,000 plus letters, so me remembering your organization's letter is actually sort of remarkable in that sense. But I wanted to say a few things based on what you were talking, and just so people understand some points. You definitely had me at hello when you talk about the necessity of federal action to address the plastic waste in the environment and in waterways issue. That's literally what my program does. One thing to note, though, is the strategy by statute. This is a statute-driven strategy. The Save Our Seas 2.0 Act of 2020 mandated that we do this strategy. And by statute, it's a domestic stakeholder strategy. So it's not just meant as an EPA or US government strategy. Although, of course, some of the actions in that draft strategy that was released for public comment are logically led by EPA or other federal agencies. I wanted to talk a little bit about the rulemaking side of things, because anyone who's read the strategy, and we got a lot of comments on this, that it's really voluntary actions and aspirational actions. It doesn't have really actions about specific rulemakings, either under the Clean Water Act or the Resource Conservation and Recovery Act or other acts relevant to addressing plastic and plastic waste. Any specific rulemakings the agency may do, and I say may, not will, would be articulated in a forthcoming implementation plan associated with the strategy. They won't be in the strategy proper. But we got a lot of comments on this. Why aren't you proposing specific rulemakings, including some of the things Henry was talking about? And rulemakings, they're a difficult endeavor. I don't want anything I say to be misconstrued, because I have my own ideas about rulemakings we maybe should be doing relevant to this space. But Henry, you already know this, I'm sure, but others may not know. Rulemakings typically take years. From idea to implementation. Even after the idea, they can take years. And so, for an example, you brought up PFAS, right? Some of you may know that there's a proposed rulemaking right now open for public comment on 9 PFAS substances that's in the Federal Register. That did not happen overnight. We had years of multiple petitions to do something on PFAS, a rulemaking on PFAS. It took years to raise the public consciousness on the dangers or potential dangers of PFAS. EPA in 2021 eventually established a PFAS council, and it was only this February 2024 that we finally proposed a rulemaking. And so, again, I don't want my message to be misconstrued that rulemakings are not worth their time. I absolutely think they have a place, but I just wanted a bit of a, let people know about the reality of how long these things actually take. Henry also talked about effluent limitation guidelines. So RCRA is not my office. That's the Office of Land and Emergency Management. Obviously, Clean Water Act is my office. Effluent limitation guidelines, which is a program that deals with, as Henry was talking about, industrial wastewater. To do something on ELGs to address microplastics, among other things, we would need to have data that shows that industrial wastewater is an important pathway for microplastics to get into the environment. And sometimes the agency will actually commission its own studies to do that. Sometimes it's looking for existing studies, but there are basically what I'm getting at is there are various steps we have to take. It's not just like, hey, this is a great idea, why don't we just do a rulemaking? You probably all realize that, but I just want to put some reality behind it. So again, I don't want to make it seem like we are saying that rulemakings aren't part of the answer. I actually do think they are, but I just wanted to put some emphasis behind what that would take. Often when I talk to my colleagues at EPA, this is a peek under the hood, but bandwidth is an issue. ELGs are working on something like 7 rules right now, and they have limited staff. And so that is a reality. For them to say, okay, we'll take on yet another rule, either the administrator or the AA for water or a statute would probably have to be the driver for that, not Rommel and Andy calling them and saying, hey, what do you think about doing a rule in this space? So I'll stop there. I know I'm standing between everyone and lunch, but I just wanted to, since this happened to be a talk that Henry was doing, and I'm coincidentally the co-lead on the strategy, I just wanted to let everyone know that. And thank you again, Henry, for your great feedback on the strategy.
Yeah, and thanks so much for doing it. I want to emphasize one more time, we were so happy to see it, and we are aware of the challenges with taking big action, and we're really grateful for the time and attention you all put into it.
Great. Thank you both very, very much. There are no more questions online, Zach. I don't know if you have any more in the room, but I did want to take this opportunity to tell those of you who are joining us on Zoom, we are going to have this Zoom link open all the way through lunch. You can choose whether to leave the meeting and come back at 1 o'clock, and I will let you back in the room, or you can leave it up on your computer while you have lunch. Either way, you can definitely come back this afternoon. And back to you, Zach.
Yeah, thank you to both Henry and Rommel. Rommel, you are always a welcome participant in anything we're doing at Clean Virginia Waterways. A quick bit of housekeeping before we break for lunch. If you're interested in a certificate of attendance for continuing education credit